Let's see what they've got for us. Outside the Supreme Court,
United States looking at immunity claims by former President Donald Trump. The case would determine if the former president can avoid criminal prosecution for his alleged role in trying to overturn
banging on pots.
the 2020 election results.
All right. Whistles. Good. That's effective. Nice. Yes, bang those pots, my friends. All right, here's some signs. Supreme Court corruption, absolute immunity, justice delayed is justice denied. Yeah, we don't have kangaroos here, okay? It's not a common animal for us here, all right? Give some slack.
United States. Mr. Sauer?
Okay, here they are. Boom, let's go.
Mr. Chief Justice, and may it please the court, without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike?
Sure.
Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies?
Definitely yes.
The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Nice.
Mr. Sauer, to your last point, could you be more precise as to the source of this immunity?
The source of the immunity is principally rooted in the executive vesting clause of Article 2, Section 1.
And how does that happen?
The source of it, Justice Thomas, I think is, as you described in your separate opinion in Zivotofsky, for example, that the executive vesting clause does not include only executive powers laid out explicitly therein, but encompasses all the powers that were originally understood to be included therein. And Marbury against Madison itself provides strong evidence this kind of immunity, a broad principle of immunity that protects the president's official acts from scrutiny, direct sitting in judgment, so to speak, of the Article 3 courts. That matches the original understanding of the executive.
So how exactly would we determine what an official act is?
I'd point the court to two cases for that. Obviously, Fitzgerald against Nixon is the best guidance that the court gives. The court adopted the outer perimeter test, and this court engaged in analysis there that's very instructive here, where it looked at the level of specificity at which the acts are described. In that case, a civil case. Here it would be the indictment.
Well, what if you have, let's say, the official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay, it's not.
Appointment would not be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
Accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts border boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official, you say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for because the what's for part is within the president's official duties?
We would say independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the premise, the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the recommendations clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case. And that's a situation which, of course, could be alleged in virtually any indictment.
Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against.
Like
now,
Trump.
I think your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or
Like Joe
orders
Biden
someone
has?
to assassinate him,
Politically?
is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
He could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful
No, because
or improper
immunity
purpose.
says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we
Harlan,
go back
Johnson,
to
and so
Justice
forth.
Can you let him
Thomas's
answer,
question,
please?
which was, where does that come from?
Stop cutting him off.
There are amici here who tell us that the founders actually talked about whether to grant immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up. Instead, they've passed an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after.
After
So-
conviction in the Senate.
Or you can impose criminal liability.
After conviction
We
in
would
the
be
Senate.
creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled, not to make a mistake, but more than that.
What?
A president is entitled for total personal gain to use the trappings of his office.
That's not what they're saying at all.
That's what you're trying to get us to hold.
Wrong.
Without facing criminal liability.
Your Honor, I would say three things in response to that. First, the doctrine that immunity does not turn on allegedly improper motivation or purpose is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe, and countless other laws that could be broken for personal gain.
All you do is
that
impeach
anyone
them
would say
and
that it would
convict
be
them.
reasonable for a president or any public official to do that.
It's not
Your Honor,
qualified.
as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
Isn't
'Cause
the
you can
work,
say it
though,
every time.
of the improper motive, at least in the absolute immunity context, to tell us what are official acts and what are not? I mean, I'd understood that even in the, well, first of all, your ask is absolute immunity, isn't it? I
That's
mean,
our principal position,
That's your
yes.
position, is you want the same kind of doctrine that we've applied in other contexts when we say an official has absolute immunity. And my
Impeachment.
understanding is that when we say that, we mean for their official acts. Is that right?
Yes.
Okay, so any official act, so then in that world, the real decision-making from the court standpoint is whether or not something is an official act or not, correct?
That is an important determination by all means.
I mean, that's the determination in the absolute immunity world, because if you determine that it's an official act, then the principle is that you get immunity for it, correct?
That is correct.
All right, so my question, and I think the Chief Justice may have asked this at the beginning, is how do you determine
He
what,
did
or
ask
maybe
that, yeah.
Justice Thomas, how do you determine what is an official act? And when we're talking about the kinds of scenarios that Justice Sotomayor brought up, one could say that when the president is using the trappings of his office to achieve a personal gain, then he's actually not acting officially, even if the doctrine was absolute immunity. So what do you say about that?
Two things in response to that. First, to the last point, that allegation that this was really motivated by an improper private purpose could be made in every single case.
No, I understand that, but it would have to be made. I'm just trying to assess, even if we had the doctrine of absolute immunity, that same allegation and the facts related to it would come in because the person would be arguing that he was not acting in his official capacity. He wasn't doing something official. He was doing it personal, correct?
I'm not sure I agree, but the point I would make in response to that is in Fitzgerald against Nixon, this court emphasized that would result in an intrusive discussion or determination of the president's personal motives for every official act. And again, this is not just in the case of the presidency.
All right, can I just ask you another quick question? At the beginning of your analysis, when you were giving your opening statement, you were talking about, you suggested that the lack of immunity and the possibility of prosecution in the presidential context is like an innovation. And I understood it to be the status quo. I mean, I understood that every president from the beginning of time, essentially, has understood that there was a threat of prosecution, if for no other reason than the Constitution suggests that they can be prosecuted after impeachment, that, the Office of Legal Counsel has said forever that presidents are amenable to a threat of prosecution, and they have continued to function and do their jobs and do all the things that presidents do. So it seems to me that you are asking now for a change in what the law is related to immunity.
No.
I would quote from what Benjamin Franklin said at the Constitutional Convention, which I think reflects best the founders' original understanding and intent here, which is at the Constitutional Convention, Benjamin Franklin said, "History provides one example only of a chief magistrate who was subject to public justice, criminal prosecution, and everybody cried out against that."
No, I understand, but since Benjamin Franklin, everybody has thought, including the presidents who've held the office, that they were taking this office subject to potential criminal prosecution, no?
I don't. I see the opposite. I see all the evidence going the other way. Marbury against Madison, Mississippi against Johnson discussed this broad immunity principle that naturally.
So what was up with the pardon for President Nixon?
And no one's been charged.
If everybody thought that presidents couldn't be prosecuted, then what was that about?
Well, he was under investigation for both private and public conduct at the time, official acts and private conduct. And I think everyone has properly understood that the president, since like President Grant's carriage riding incident, everyone has understood that the president could be prosecuted for private conduct.
On that score, there does seem to be some common ground between you and your colleague on the other side, that no man's above the law and that the president can be prosecuted after he leaves office for his private conduct. Is that right?
We agree with that.
And then the question becomes, as we've been exploring here today, a little bit about how to segregate private from official conduct that may or may not enjoy some immunity. And I'm sure we're going to spend a lot of time exploring that. But the D.C. Circuit in Blazing Game, Chief Judge there, joined by the panel, expressed some views about how to segregate private conduct for which no man is above the law from official acts. Do you have any thoughts about the test that they came up with there?
Yes, we think in the main that test, especially if it's understood through the lens of Judge Katsas' separate opinion, is a very persuasive test. It would be a great source for this court to rely on in drawing this line. And it emphasizes the breadth of that test. It talks about how actions that are, plausibly connected to the president's official duties are official acts. And it also emphasizes that if it's a close case or it appears there's considerations on the other side, that also should be treated as immune. Those are the aspects of that we'd emphasize as potentially guiding the court's
discretion. And that left open,
here.
in that case, the possibility of further proceedings and trial.
Exactly right. And that would be a very natural course for this court to take in this place. The court can and should reverse the categorical holding of the D.C. Circuit that there's no such thing as official acts, especially when it comes to...
But you'd agree further proceedings would be required.
That is correct. And I would point the court to Anderson against Crate, where the court said there'd be kind of two stages to these further proceedings. There's looking at the indictment itself, or in that case it was a complaint, but look at the charging document itself and see whether on the face of it this is alleging official acts. And if not, or it can't be determined, then there'd be a factual proceeding. And all that under Mitchell against Forsyth and so forth would have to occur before any other proceedings in the district.
Mr. Sauer, you began by explaining why you believe that immunity from criminal prosecution is essential for the proper functioning of the presidency. But my question is whether the very robust form of immunity that you're advocating is really necessary in order to achieve that result. So just to take one possible alternative, suppose the rule were that a former president cannot be prosecuted for official acts unless no plausible justification could be imagined for what the president did, taking into account history and legal precedent and the information that was provided to the president at the time when the act was taken. Would that be sufficient, or if it is insufficient, why would it be insufficient?
That might be a much better rule than what emerged from the lower courts here. We think it would be insufficient because, again, that long line of cases talking about using the president's motives and the intrusive sort of consideration of the president's motives as transforming acts to official and unofficial would come into play. And of course, once you can make that allegation, all of a sudden you've opened the door. You no longer have a per se clear bright line rule. You have a determination in every single case.
Where do you think the D.C. Circuit went wrong in how it determined what was official versus what's personal?
Well, I read the opinion below in this particular case as adopting a categorical view. It does not matter is the logic of their opinion, because there is no immunity for official acts, and therefore, that's the end of the story. I don't really think they went wrong in Blasingame in the civil context when they engage in the same determination with respect to what's official and what isn't official. There, we agree with most of what that opinion says.
And for some official acts that are not within the Article II exclusive power, okay, so official acts but not within the Article II exclusive power, even for those, I assume you would think that a clear statement has to be required, a clear statement in the statute covering the president if the president's official acts are going to be criminalized.
Absolutely. Obviously, the issue is, at the highest possible level when it comes to the unrestrictable powers, like as in this indictment, the
Well, I'm assuming the exclusive powers are walled off and can't be prosecuted before there's a lot of official powers that are not exclusive to the president under his Article II authority.
Interesting.
But for those, I understood you to be saying at a minimum there would need to be a clear statement in the statute referencing the president so that the president's on notice and can conduct himself or herself accordingly.
That's absolutely correct, and that'd be consistent with Franklin and Public Citizen and cases along a series of other clear statements.
Can I follow up on that? So you concede that private acts don't get immunity?
We do.
Okay. So in the special counsel's brief on pages 46 and 47, he urges us, even if we were to decide or assume that there was some sort of immunity for official acts, that there were sufficient private acts in the indictment for the case to go back in the trial to begin immediately. And I want to know if you agree or disagree about the characterization of these acts as private. Petitioner turned to a private attorney, was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election results. Private?
As alleged. I mean, we dispute the allegation, but that sounds private to me.
Sounds private. Petitioner conspired with another private attorney who caused the filing in court of a verification signed by petitioner that contained false allegations to support a challenge.
That also sounds private.
3 private actors, 2 attorneys, including those mentioned above, and a political consultant helped implement a plan to submit fraudulent slates of presidential electors to obstruct the certification proceeding, and petitioner and a co-conspirator attorney directed that effort.
You read it quickly. I believe that's private. I don't want to...
So those acts you would not dispute. Those were private, and you wouldn't raise a claim that they were official.
As characterized. What we would say, Your Honor, if I may, what we would say is official is things like meeting with the Department of Justice to deliberate about who's going to be the acting Attorney General of the United States.
Sure.
Communicating with the American public.
And those
communicating with Congress
parties.
about matters of enormous
Thank you. Thank you.
Not the president.
Thank you, counsel. And what is the consequence in terms of going forward with your acknowledgement that those are private acts as opposed to official acts?
If you look at the indictment here, there's a bunch of acts that we think are just clearly official.
Right.
There may be allegations that mostly relate to what the government has described here as private aim or private end, and the court should remand or address itself, but remand for a Brewster-like determination, which is what's official and what's private. The official stuff has to be expunged completely from the indictment before the case can go forward, and there has to be a determination, at least on remand, of what's official, a 2-stage determination of what's official and what's private.
Well, if you expunge the official part from the indictment, how do you, that's like a one-legged stool, right? Giving somebody money isn't bribery unless you get something in exchange. And if what you get in exchange is to become the ambassador to a particular country, that is official, the appointment. It's within the president's prerogatives. The unofficial part is I'm going to get $1 million for it. So if you say you have to expunge the official part, how does that go forward?
This particular indictment, where we say virtually all the overt conduct is official, we don't believe it would be able to go forward. There could be a case where it would, but if you look at even the government's brief in this case divides up the indictment into things that, other than the electors' allegations, they haven't disputed that they are official acts, but what they do is say, well, we tie it all together by characterizing it as done, and these are the allegations that the court just referred to, by an improper private aim or private end. Again, that's their words, and that just runs loggerheads, dead set against this court's case law, saying you don't look at, when immunity determinations, the motive, improper motivation or purpose.
Thank you. Justice Thomas?
In assessing the official acts of a president, do you differentiate between the president acting as president and the president acting as candidate?
Yes, we do, and we don't dispute, essentially, the blazing game discussion of that.
Okay.
But, of course, that has to be done by objective determinations, not by looking at what was the purpose of what you did this. That's the most important point.
Did you, in this litigation, challenge the appointment of special counsel?
Not directly. We have done so in the Southern District of Florida case, and we totally agree with the analysis provided by Attorney General Meese and Attorney General Mukasey.
Yes.
And it points to a very important issue here, because one of their arguments is, of course, that, we should have this presumption of regularity. That runs into the reality that we have here an extraordinary prosecutorial power being exercised by someone who was never nominated by the president or confirmed by the Senate at any time. So we agree with that position. We hadn't raised it yet in this case when this case went up on appeal.
Jack Smith is illegal.
Justice Alito?
When you say that the official act should be expunged from the indictment, that in itself would not achieve very much unless evidence of those official acts were precluded at trial. So is that what you're saying, that prosecution should not be permitted at trial to prove the official acts as part of the conspiracies that are alleged?
Absolutely, and we think that's just the clear implications of Brewster and Johnson and their discussion in this very analogous context.
Thank you.
Justice Kagan?
I can continue on in Justice Barrett's vein a little bit and ask you about some of the allegations of the indictment and whether they're official acts or not in your view. So the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor.
I don't think we've disputed that that's official. I'm sorry, that is unofficial.
That's unofficial. Same for the defendant called the chairwoman of the Republican National Committee, asked her to gather electors in targeted states, falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor.
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power.
They did it in Hawaii.
Couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case, and based on the allegations, we think it's clear he did not, that this was done in an official capacity.
Jack Smith
The defendant asked the
incorporated that
Arizona
into his
House
indictment.
Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to
Yes.
communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to
100%.
communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is extremely strong precedent from this court.
Does it
doesn't
strike you
matter.
as odd that your understanding of immunity goes way beyond what OLC has ever claimed for the former president?
I view the
legal
OLC
counsel.
opinions here as strongly supporting us, because any time a congressional statute basically got anywhere near touching the president's prerogatives, they've said, oh, we're going to interpret the statute narrowly to avoid that.
And they've
Well,
never
that's a
prosecuted.
different question.
Never.
I mean, what OLC has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president, but that's a very different argument
Give me a break.
than the immunity claim that you're making here,
Your
which
immunity expires
OLC
in
has
office when
definitively
you leave?
not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty.
Yeah.
That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
Thank you.
Justice Gorsuch?
Just returning to the Chief Justice's hypothetical about the ambassador sale and bribery. Congress has a statute that specifically names the president and says he can be criminally prosecuted for bribery, presumably after he leaves office. Outside the core areas that Justice Kavanaugh was talking about, when when Congress speaks clearly, couldn't a statute like that, Congress provide a statute like that, that would allow all manner of evidence to come in to prove the case?
I think our position is that would have to be an unofficial act, purely private conduct for that prosecution to go forward.
All right, but outside the core areas of executive power, if there is a clear statement from Congress that something is unlawful and it applies to the president, I'm struggling to see why in that case, perhaps the evidence could come in.
Yeah, the strongest possible case, in our view, is what you've described as kind of the core executive powers, the unrestrictable powers within the meaning of SELA law. But again, the holding of, for example, Brewster and Johnson that we've relied on doesn't turn on how central it is of a legislative act. It just says if it's an official act, which here we would say applies basically the outer perimeter test of Fitzgerald against Nixon, that doesn't come in.
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they were engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
Didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, one of the checks and balances, in addition to impeachment that you've discussed, is subordinate liability. You don't contest that everybody following an unlawful order beneath the President of the United States can be immediately prosecuted, do you?
The court is asking whether they
If the President gives an unlawful order, call in the troops, all the examples we've heard, every subordinate beneath him faces criminal prosecution, don't they?
That is what Gouverneur Morris said explicitly at the Constitutional Convention, that his co-agitators could be prosecuted. There is an important caveat because, of course, there would have to be a statute that would govern that for them to be prosecuted.
Oh, we've got lots of statutes.
Yes,
the criminal law books are replete. But do you agree, is that one check that's available?
Absolutely. And again, the only caveat that I was making is if that statute was doing what Marbury says you can't do, which is going after the subordinates to restrict, for example, a core executive function, the Franklin Clear Statement Rule might be triggered, and you might not be able to go after that president. So I don't think Congress can say, well, we can't go after the president directly, but we're going to criminalize the way that the president speaks to Congress under the exercise of the Recommendations Clause, and therefore we're going to put in a criminal statute that says if you provide false information to Congress in carrying out the president's recommendation powers, you can be immediately prosecuted. That would at least be a very difficult question. But the fundamental point of drawing that distinction between the president himself and his coadjutors, in the word of Gouverneur Morris of the Constitutional Convention, is an excellent distinction.
Okay, so
Justice Barrett? So, Mr. Sauer, you've argued that the impeachment clause suggests or requires impeachment to be a gateway to criminal prosecution, right?
Yes, I think that's the plain meaning of that second phrase in the clause.
Okay, so there are many other people who are subject to impeachment, including the 9 sitting on this bench, and I don't think anyone has ever suggested that impeachment would have to be the gateway to criminal prosecution for any of the many other officers subject to impeachment. So why is the president different when the impeachment clause
Because he's the executive branch.
Someone very important has made the opposite suggestion as to the president himself, which is Solicitor General Bork, which is reaffirmed in the OLC opinions on this, where Solicitor General Bork in 1973, as to the issue of the vice president, reviewed the historical materials, and he said the sequence is mandatory only as to the president. That is DOJ's view of the original understanding of the impeachment judgment clause, which is exactly our position. The sequence is mandatory only as to the president. Keep in mind that the criminal prosecution of a president prior to impeachment contradicts, in our view, the plain language of the Constitution, but also hundreds of years of history. And what DOJ admits is the framers' intent. And so we say that practice, whatever its validity, should not be extended to this novel context where it clashes with the constitutional structure.
What if the criminal conduct isn't discovered until after the president is out of office? So there was no opportunity for impeachment.
We say the framers assumed the risk that of under-enforcement by adopting these very structural checks. As Justice Scalia said in Morrison against Olson, the separation of powers prevents us from righting every wrong, but it does so that we do not lose liberty.
Okay, and the special counsel makes a point that I think is a pretty compelling one. You admit that if the president were successfully impeached, that he could be criminally prosecuted after impeachment, right?
Assuming the prosecution was for the same conduct of which he was convicted, not impeached. He must be convicted. That word conviction is right right there in the clause.
Okay, granted. But you also say that these criminal statutes, unless they explicitly mention the president, don't apply to him. So how can you say that he would be subject to prosecution after impeachment while at the same time saying that he's exempt from these criminal statutes?
Well, there are statutes, as they concede, where Congress has purported to do so.
2 or 3.
They haven't done a comprehensive review. I think it looks like all they did was text search for president in 18 U.S. Code. Again, under Franklin, that's a very telling indication that the word president is not in the statute. Isn't necessarily a magic word requirement, so to speak. But more fundamentally than that, they concede there are statutes that exist. In addition to that, much impeachment occurs as a result of private conduct. So the impeachment judgment clause does do significant work by authorizing the subsequent prosecution of a president there, because what the framers, if you look at what they're discussing in the thing, or in the Constitutional Convention, is principally concerns about private conduct, which of course we concede are not immune.
Okay, so just to pick up Justice Kagan's example of a president who orders a coup, let's imagine that he is impeached and convicted for ordering that coup, and let's just accept for the sake of argument your position that that was official conduct. You're saying that he couldn't be prosecuted for that even after conviction and impeachment proceeding if there was not a statute that expressly referenced the president and made it criminal for the president.
There would have to be a statute that made a clear statement that Congress purported to regulate the president's conduct.
Okay, thank you.
Justice Jackson?
So I think I now understand better your position. In your discussions with Justice Kavanaugh, it became clear that you are saying that for the private acts of a president, there's no immunity, but for the official acts of the president, there is immunity. Is that your position?
I agree with that.
All right. So one thing that occurs to me is that this sort of difficult line drawing problem that we're having with all of these hypotheticals, is this a private act or a public act, is being necessitated by that assumption. Because of course, if official acts didn't get absolute immunity, then it wouldn't matter. We wouldn't have to identify which are private and which are public, correct?
That, in fact, is the approach of the D.C. Circuit. There's no determination that needs to be made.
Right. I'm just making, so to the extent we're worried about, like, how do we figure out whether it's private or public, we have to understand that we're only doing that because of an underlying assumption that the public acts get immunity. So let me explore that assumption. Why is it, as a matter of theory, and I'm hoping you can sort of zoom way out here, that the president would not be required to follow the law when he is performing his official acts? Everyone else, there are lots of folks who have very high-powered jobs, who make a lot of consequential decisions, and they do so against the backdrop of potential criminal prosecution if they should break the law in that
She clearly doesn't understand
capacity.
it.
And we understand and we know, as a matter of fact, that the President of the United States has the best lawyers in the world. When he's making a decision, he can consult with pretty much anybody as to whether or not this thing is criminal or not.
All the lefties talk so much.
Would we have a situation in which we would say that the president should be making official acts without any responsibility for following the law?
I respectfully disagree with that characterization. The president absolutely does have responsibility. He absolutely is required to follow the law in all of his official acts. But the remedy for that is the question: could he be subject to personal vulnerability, sent to prison for making a bad decision after he leaves office?
But other people who have consequential jobs and who are required to follow the law make those determinations against the backdrop of that same kind of risk. So what is it about the president? I mean, I've heard you say it's because the president has to be able to act boldly, make kind of consequential decisions. I mean, sure, but again, there are lots of people who have to make life and death kinds of decisions, and yet they still have to follow the law, and if they don't, they could be sent to prison, et cetera. So
I say two things in response to that, both from Fitzgerald. That's the very sort of inference or reasoning that this court rejected in Fitzgerald.
No, but let me just, Fitzgerald was a civil situation in which the president actually was in a different position than other people because of the nature of his job, the high-profile nature, and the fact that he touches so many different things. When you're talking about private civil liability, anybody on the street can sue him. We could see that the president was sort of different than the ordinary person when you say, should he be immune from civil liability from anybody who wants to sue him? But when we're talking about criminal liability, I don't understand how the president stands in any different position with respect to the need to follow the law as he is doing his job than anyone else.
He just has extra protection.
He is required to follow the law.
Gosh.
But he's not if there's no criminal prosecution. If there's no threat of criminal prosecution, what prevents the president from just doing whatever he wants?
All the structural checks that are identified in Fitzgerald and a whole series of this court's cases that go back to Martin against Mott, for example, impeachment, oversight by Congress, public oversight. There's a long series of Fitzgerald
subordinates can't break the law.
This in the civil context.
Re-election.
And we think that language is actually important.
I'm not sure that that's much of a backstop. And what I'm, I guess, more worried about, you seem to be worried about the president being chilled. I think that we would have a really really significant opposite problem if the
Why?
president wasn't chill. If someone with those kinds of powers, the most powerful person in the world, with the greatest amount of authority, could go into office knowing that there would be no potential penalty for committing crimes, I'm trying to understand what the disincentive is from turning the Oval Office into the seat of criminal activity in this country.
I don't think there's any
It
allegation
is the seat
of
of
that. In this
criminal
case,
activity
what George
right now.
Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife.
Thank you.
Mr. Dreeben?
Mr. Chief Justice,
Mixed bag
and may
there.
it please the court. This court has never recognized absolute criminal immunity for any public official.
This guy sounds exactly
Petitioner,
like he looks.
however, claims that a former president has permanent criminal immunity for his official acts unless he was first impeached and convicted. His novel theory would immunize former presidents for criminal liability for bribery, treason, sedition, murder, and here conspiring to use fraud to overturn the results of an election and perpetuate himself in power. Such presidential immunity has no foundation in the Constitution. The framers knew too well the dangers of a king who could do no wrong. They therefore devised a system to check abuses of power, especially the use of official power for private gain. Here, the executive branch is enforcing congressional statutes and seeking accountability for petitioners' alleged misuse of official power to subvert democracy. That is a compelling public interest. In response, petitioner raises concerns about potential abuses, but established legal safeguards provide layers of protections, with the Article III courts providing the ultimate check. The existing system is a carefully balanced framework. It protects the president, but not at the high constitutional cost of blanket criminal immunity. That has been the understanding of every president from the framing through Watergate and up to today. This court should preserve it. Welcome the court's questions.
Mr. Dreeben, does the president have immunity? Are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article II branch, can assert, as applied, Article II objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions.
Wait, what?
That is the constitutional doctrine that currently governs the separation of powers. What petitioner is asking for is a broad blanket immunity that would protect the president, a former president, from any criminal exposure absent impeachment and conviction, which has never happened in our history. And we submit that is not necessary in order to assure that the president can perform all of the important tasks that the Constitution reposes in him.
Not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions.
Yes.
Why? If what you're saying is right, it would seem that that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes. And I want to explain why there are layers of safeguards that assure that former presidents do not have to lightly assume criminal liability for any of their official acts. At the outset, there is a statutory construction principle that is applicable here, arises when there is a serious constitutional question about applying a criminal statute to the president's acts. It is not, and I'm sure that we will discuss this, that no statute can apply to the president in his official capacity absent a designation of the president in it. But there is a principle that if there is a serious constitutional question, courts will strive to construe the statute so that it does not apply to the president. In addition to that, the president, I think has been mentioned earlier, has access to advice from the Attorney General, and it would be a due process problem to prosecute a president who received advice from the Attorney General that his actions were lawful, absent the kind of collusion or conspiracy that itself represented a criminal violation, which I don't really see as being a realistic option.
An excuse, kind
and
of
then
an
if I
escape
could say one more
exception
thing,
for
because
Trump.
you raised the question about potential overseas taking of life. And the Office of Legal Counsel has addressed this quite specifically. There is a background principle of criminal law called the public authority exception to liability, and it is read into federal law unless Congress takes specific action to oust it, which it never has done as far as I am aware. And in a case in which the president sought to engage in overseas activity that would result in the taking of life, OLC did not say the federal murder statute doesn't apply. That would be the thrust of my friend's argument on clear statement. Instead, OLC went through an extensive analysis on why the public authority defense would prevent it from being considered a violation of law to go after a terrorist, for example.
The Court of Appeals below, whose decision we're reviewing, said, quote, a former president can be prosecuted for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the laws. Do you agree with that statement?
Well, I think it sounds tautologically true, but I want to underscore that the obligation of a president is to take care that the laws are faithfully executed.
I think it sounds tautologically true as well, and that, I think, is the clearest statement of the court's holding, which is why it concerns me. As I read it, it says simply, a former president can be prosecuted because he's being prosecuted.
Well, I would not suggest that that's either the proper approach in this case or certainly not the government's approach. A prosecution does, of course, invoke federal criminal law. The allegations have to be presented to a grand jury, which votes upon the indictment.
Jury.
Well, that's what I mean, shortly after that statement in the court's opinion, that's what they said, but there's no reason to worry because the prosecutor will act in good faith.
Trust us.
And there's no reason to worry because a grand jury will have returned the indictment. Now, you know how easy it is in many cases for a prosecutor to get a grand jury to bring an indictment, and reliance on the good faith of the prosecutor may not be enough in some cases. I'm not suggesting here. So if it's tautological, and those are the only protections that the Court of Appeals below gave, and that is no longer your position, you're not defending that position, why shouldn't we send it back to the Court of Appeals or issue an opinion making clear that that's not the law?
Well, I am defending the Court of Appeals judgment, and I do think that there are layered safeguards that the court can take into account that will ameliorate concerns about unduly chilling presidential conduct. That concerns us.
By prosecutor
we are
hacks.
not endorsing a regime that we think would expose former presidents to criminal prosecution in bad faith.
This dude's whole career has been prosecuting
without adequate
Trump.
Evidence. A politically driven prosecution would violate the Constitution under Waite versus United States. It's not something within the arsenal of prosecutors to do. Prosecutors take an oath. The Attorney General takes an oath. So
give me a break.
I don't want to overstate Your Honor's concern with potentially relying solely on good faith. But that's an ingredient, and then the courts stand ready to adjudicate motions based on selective prosecution, political animus. This court relied on those very protections in the Vance case just 2 years ago.
Ignore those too, Michael.
What concerns me is, as you know, the Court of Appeals did not get into a focused consideration of what acts we're talking about or what documents we're talking about because of its adoption of what you termed, and I agree quite correctly, as a tautological statement. Because the fact of prosecution was enough to take away any official immunity, the fact of prosecution, they had no need to look at what courts normally look at when you're talking about a privilege or immunity question.
Well, I think I would take issue, Mr. Chief Justice, with the idea of taking away immunity. There is no immunity that is in the Constitution unless this court creates it today. There certainly is no textual immunity. We do not submit that that's the end of the story. United States versus Nixon wasn't a textually based case. Neither was Nixon versus Fitzgerald. We endorse both of those. A lot of stuff is not in the text of the Constitution, man. What is important is that no public official has ever had the kind of absolute criminal immunity that my friend speaks of, even with respect to the speech or debate clause. It's very narrow. It's focused on legislative acts. It's not focused on everything that a congressman does. And it responds to a very specific historical circumstance that basically involved the two other branches potentially harassing legislators and preventing them from doing their jobs. That's why it ended up in the Constitution. Nothing like that ended up in the Constitution for the presidents. And that's because one of the chief concerns of the framers was the risk of presidential misconduct. They labored over this. They adopted an impeachment structure that separated removal from office as a political remedy from criminal prosecution. This departed from the British model. The British model was you get impeached and criminally prosecuted and convicted in the same proceeding. The framers did not want that. They wanted a political remedy in case a president was engaging engaging in conduct that endangered the nation. He could be removed. He can't be prosecuted while he's a sitting president. That's been the longstanding Justice Department position.
Mr. Dreeben, you dispute the proposition that a former president has some form of immunity. But as I understand your argument, you do recognize that a former president has a form of special protection, namely that statutes that are applicable to everybody must be interpreted differently under some circumstances when they are applied to a former president. Isn't that true?
It is true because, Justice Alito, of the general principle that courts construe statutes to avoid serious constitutional questions, and that has been the longstanding practice of the Office of Legal Counsel
unless they're prosecuting
in
Trump.
the Department of
All
Justice.
right, so this is more, I think, than just a quarrel about terminology,
Yeah,
whether
it's
what
not
the former
semantics, it's
president
labels.
gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss, may cite OLC opinions, and the district court may say, well, that's fine. I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time. And during the trial, the former president may be unable to engage in other activities that the former president would want to engage in. And then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term.
So we don't end up in a
Congress is
situation like
unlikely
this
to crank
with 4
up the
criminal
machinery to
charges
do
in
it.
1
And
year.
if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all. So
you're arguing against the most far-reaching aspects of Mr. Sauer's argument.
that is correct. And let me turn then to why.
Well, what about, to unpack it a little more, do you agree that there's some aspects of Article II presidential power that are exclusive and that Congress cannot regulate and therefore cannot criminalize?
Absolutely.
Okay. For other official acts that the president may take that are not within that exclusive power,
So
assume
there is
for the
some
sake
immunity.
of argument, this question, that there's not blanket immunity for those official acts, but that to
Which is not Sauer's
preserve the
argument.
separation of powers, to provide fair notice, to make sure Congress has thought about this, that Congress has to speak clearly to criminalize official acts of the president by a specific reference. That seems to be what the OLC opinions suggest. I know you have a little bit of a disagreement with that, and what this court's cases also suggest.
So, Justice Kavanaugh, I'd like to take all of those in turn because I don't think this court's cases speak that broadly. I definitely don't think that the Office of Legal Counsel opinions stand for this broad proposition that unless the president is specifically named, he's not in the statute. And I don't think that that's necessary in order to afford adequate protection for the president's valid Article II functions.
Well, you said unless, sorry to interrupt, but I want to just get this out and you can incorporate it in the answer. You said unless there's a serious constitutional question.
Correct.
Well, it's a serious constitutional question whether a statute can be applied to the president's official acts. So wouldn't you always interpret the statute not to apply to the president, even under your formulation, unless Congress had spoken with some clarity?
I don't think across the board a serious constitutional question exists on applying any criminal statute to the president.
The problem is the vague obstruction and 371 conspiracy to defraud the United States can be used against a lot of presidential activities historically with a creative prosecutor who wants to
do whatever they want.
go after a president.
Let me try to.
That's what we're talking about historically is the risk and going forward the risk. So you can take all of that.
I think that the question about the risk is very serious, and obviously it is a question that this court has to evaluate. For the executive branch, our view is that there is a balanced protection that better serves the interest of the Constitution, that incorporates both accountability and protection for the president. And I want to go through the protections that do exist, but perhaps it's worth returning at the outset to the statutory construction question that you raised. The Office of Legal Counsel has said the offense of bribery, of course, applies to the the president. It does not name the president, Justice Gorsuch. Section 201 does not specifically name the president.
I would assume that's personal. So
well, I think
that's what Brewster said.
Bribery statute in 607 says the president. I've got it in front of me. And so there is that. Let me just back up, though, what was a quick exchange with Justice Kavanaugh that I just want to make sure I understand.
Yeah.
Did you agree that there are some core functions of the executive that president conduct that Congress cannot criminalize?
Yes.
So is that a form? I mean, we can call it immunity, or you can call it they can't do it, but what's the difference?
We call it an as-applied Article 2 challenge.
Okay. Can we call it immunity just for shorthand's sake? So I think we are kind of narrowing the ground of dispute here. It seems to me there is some area you can
Clearly
see
there's
that
immunity.
An official acts that Congress cannot criminalize. And now we're just talking about the scope.
Well, I don't think it's a just, but I think it's a very significant gap between any official act and the small core of exclusive official acts.
I got that, but I want to explore that, okay? So, for example, let's say a president leads a mostly peaceful protest sit-in in front of Congress because he objects to a piece of legislation that's going through, and it in fact delays the proceedings in Congress. Now, under 1512C2, that might be corruptly impeding an official proceeding. Is that core and therefore immunized, or whatever word, euphemism you want to use for that?
Euphemism.
Or is that not core and therefore prosecutable without a clear statement that applies to the president?
It's not core. The core kinds of activities that the court has acknowledged are the things that I would run through the Youngstown analysis. And it's a pretty small set, but things like the pardon power, the power to recognize foreign nations, the power to veto legislation, the power to make appointments, these are things that the Constitution specifically allocates to the president. Once you get out...
A president then could be prosecuted for the conduct I described after he leaves office?
Probably not, but I want to explain the framework of why I don't think that that would be prosecution that would be valid. First, I think you need to run through all of the sort of normal categories of analysis. Is there a serious constitutional question that's posed by applying that statute to the president? If so, then you may well default to it does not apply, at least on that fact
I thought you said it. That was my question.
Yes,
and
I
understand.
understand.
It fell outside that core, we'll call it immunity for simplicity's sake.
Yes, I understand. There's a separate category.
Okay, so why couldn't he be prosecuted for leading a civil rights protest in front of the Capitol that delays a vote on a piece of important legislation?
So I think what you need to do is run through all of the very president-specific protective layers of analysis. So one of them is whether the statute would be construed not to apply to his conduct, even if it's not part of that small core of things that Congress can't regulate at all. If it operates to prevent the president from fulfilling his article...
No, he could have given speeches against it. He did. He did something more, and it corruptly impeded and sought to influence an official proceeding.
We're starting with the layers, I think, of protection, and we're now down through whether the statute would be construed to apply to him. Then there'd be a question of whether...
Assume it does.
None of this analysis happened with Chuck.
Then there's a question of whether he has the state of mind necessarily to
Assume he
violate
does.
it.
Corrupt.
Okay.
Nobody knows what corrupt intent means. We've been around that tree
We will
twice
probably
already.
find out.
Maybe it means that he knows that he was doing wrong, is what the government told us.
Right.
He knows he's doing wrong. He knows he shouldn't be out there blocking the congressman from going.
Well, let me get to the next layer then, which is that the president does have access to the attorney general to provide legal advice and regularly gets legal advice from the attorney general on the lawful scope of the president's activities. Wow. We could go down two tracks here. One is that the attorney general advises him that as an incident of his Article 2 authority and in carrying out the functions of the presidency, he can lawfully participate in that protest. It's kind of the First Amendment analog to the president's official powers, which the court is exploring in other cases. Alternatively, the attorney general could advise him, I'm sorry, Mr. President, there's nothing in the language of this statute that carves you out. I don't see a serious constitutional question in it because you don't have to do that. And I would advise you not to criminal law.
And then he could be prosecuted.
No.
No. If he gets a negative opinion from the attorney general, he still couldn't be prosecuted?
I'm going to assume that most presidents are not going to take
but if he gets one and does it anyway, then he could be prosecuted.
Well, so then if we are down at that level, I think what we are really asking is whether the president is subject to the criminal law. And our answer is yes, he is subject to the criminal law.
Mr. Dreeben, can we go back to the bribery statute? I, like you,
his process
understand
is totally
that the only thing that is covered by that
mechanics.
is the president is barred from soliciting or receiving funds in any room or building in the United States.
That's correct. And it's an extremely...
official building. It's a very limited mention of it.
And it really, I think,
so as I understand is there's two very limited provisions mentioning the president as included.
That's right.
There's a whole number of provisions that exclude the president, many, many, many more that exclude the president, correct?
It's a kind of small number on both sides of the
Now,
fence,
Justice Barrett made the point that if we say a president can't be included in a criminal law unless explicitly named, then that would bar the Senate from impeaching him for high crimes or misdemeanor, because that means that he's not subject to the law at all, correct?
So I think
that's a tautology you can't escape.
Justice Sotomayor, what I think that Justice Barrett was saying, and we would agree with it, is that under my friend's position, after impeachment, he could be prosecuted. But under his statutory construction approach, there'd be nothing to prosecute him for.
Exactly. That's the point, which is if he's not covered by the criminal law, he can't be impeached for it, for violating it. All right. Now, could we go further on this clear statement rule? The situations, and you mentioned it earlier, in which we have looked to see if the president is covered is contextual, correct?
Correct.
And what are the factors that generally we'll look at? I'm thinking specifically about whether the APA covers the president.
Correct.
And what we did there was to analyze what powers were being given to in the lawsuit, and et cetera. We looked at words, we looked at structure, we looked at separation of powers issues relating to our case law that said you can't direct the president to do anything, and this would have been a subterfuge for that, correct?
All correct.
So I don't know why two of my colleagues, how they would fashion a clear statement rule that would say when the law says any person can't accept a bribe, that permits the president to do it.
I agree, Justice Sotomayor, that the way that this court has interpreted statutes that do carve out the president, Justice Kavanaugh asked about this, was very context specific. The Franklin case basically involved a holding that we are highly unlikely to say that the president is an agency, something that the government said would be a peculiar understanding of agency, when the effect of it would be that we would review the president's decisions under statutes for abuse of discretion, which is a very extraordinary thing to do. I think even going back to Marbury is perhaps a point on which I agree with my friend. Marbury says discretionary acts of the president are not the kind of thing that the court reviews.
Dreeben, do you really, presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake, he's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does.
Just talk to your
He's
lawyer.
under a constitutional obligation, supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as malum in se statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute that particular application of 371, conspiracy to defraud the United States, to the particular facts here. But would you not agree that that is a peculiarly open-ended statutory prohibition? In that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest.
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah,
we don't want rigged elections.
I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes, and then Congress, extraordinary joint session, certifies the vote. And the president president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying
the president has
you
a
can't
duty
use
to
fraud
execute
to
the laws.
defeat that function. You
The
can't
laws include not
obstruct it
having
through
a rigged,
deception.
stolen election.
You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel.
As you've indicated, this case has huge implications for the presidency, for the future of the presidency, for the future of the country, in my view. You've referred to the department a few times as having supported the position. Who in the department? Is it the president, the attorney general?
The Solicitor General of the United States. Part of the way in which the special counsel functions is as a component of the Department of Justice. The regulations envision that we reach out and consult, and on a question of this magnitude that involves equities that are far beyond this prosecution as the questions of the court.
Solicitor General.
Yes.
Okay. Second, like Justice Gorsuch, I'm not focused on the here and now of this case. I'm very concerned about the future. And I think one of the court's biggest mistakes was Morrison versus Olson. I think that was a terrible decision for the presidency and for the country, and not because there were bad people who were independent counsels, but President Reagan's administration, President Bush's administration, President Clinton's administration were really hampered, in their view, all three, by the independent counsel structure. And I'm worried about here is that was kind of, let's relax Article 2 a bit for the needs of the moment. And I'm worried about the similar kind of situation applying here. That was a prosecutor investigating a president in each of those circumstances, and someone picked from the opposite party, the current president, and usually was how it worked. And Justice Scalia wrote that the fairness of a process must be judged on the basis of what it permits to happen, not what it produced in a particular case. You've emphasized many times regularity of the Department of Justice. And he said, and I think this applied to the independent counsel system, and it could apply if presidents are routinely subject to investigation going forward. One thing is certain, however, it involves investigating and perhaps prosecuting a particular individual. Can one imagine a less equitable manner of fulfilling the executive responsibility to investigate and prosecute? What would the reaction be if, in an area not covered by this statute, the Justice Department posted a public notice inviting applicants to assist in an investigation and possible prosecution of a certain prominent person? Does this not invite what Justice Jackson described as picking the man and then searching the law books or putting investigators to work, pin some offense on him?
Find the man, I'll show you the crime.
To be sure, the investigation must relate to the area of criminal offense specified by statute, but that has often been, and nothing prevents it from being very broad. I paraphrased at the end because it was referring to the judges. That's the concern going forward, is that the system, when former presidents are subject to prosecution, in the history of Morrison versus Olson tells us it's not going to stop. It's going to cycle back and be used against the current president or the next president,
4 times this year.
and the next president, and the next president after that. All that, I want you to try to allay that concern. Why is this not Morrison v. Olson redux if we agree with you?
Well, first of all, the independent counsel regime did have many structural features that emphasized independence at the expense of accountability. We don't have that regime now, but even under that regime, Justice Kavanaugh, I think if you look at Lawrence Walsh's report on Iran-Contra, I think this goes to a very fundamental point for the court to consider. Judge Walsh said, I investigated these matters. The proof did not nearly come close to establishing criminal violations. So we've lived from Watergate through the present, through the independent counsel era with all of its flaws, without these prosecutions having gone off on a runaway train.
Mr. Dreeben, I want to pick up with that public authority defense. So I'm looking at the OLC memo that David Barron wrote that you cited in your briefs. And he describes the public authority defense citing the model penal code. There are a few different definitions, but I'll just highlight this one. Justifying conduct which is required or authorized by the law defining the duties or functions of a public officer, the law governing the armed services or lawful conduct of war, or any other provision of law imposing a public duty. That sounds a lot like dividing a line between official and private conduct. I think it's narrower, and I recognize it's a defense, not an immunity. But when you look at the definition of it, are you acting within the scope of authority conferred by law or discharging a duty conferred by law? I think it's narrower than Blasingame, narrower than Nixon versus Fitzgerald, but that's what it sounds like to me. Do you agree or disagree?
You know, Justice Barrett, I certainly understand the intuition that when you act outside of your lawful authority, you've kind of gone on a frolicking detour, you're no longer carrying it out. I don't really think that that quite works for presidential activity. The only way that he could have implemented the orders is by exercising his commander-in-chief authority over the armed forces or his authority to supervise the executive branch. Those seem like core executive executive acts, to me, there is such a possibility as an unlawful executive act.
I'm not sure that I understand your answer. I mean, I was thinking, it seemed to me that in your briefs and today, when you referred to the public authority defense, you said that's one of the built-in protections and why immunity is not necessary. Because in some of these instances, when the president takes such actions that, you know, the court's been asking you, might this result in criminal prosecution? You say, well, he could raise this public authority defense. And so I'm saying, isn't this public authority defense, if raised, doesn't it sound like a defense that says, well, I was authorized by law to discharge this function,
and therefore I acted lawfully.
Therefore, I acted lawfully and I'm not criminally liable.
Correct.
Does that involve a look into motives? Kind of gets to what Justice Gorsuch was asking you. Could you say I was acting within the scope of my authority by granting a pardon, removing a cabinet officer, but then the public authority defense might not apply because you had a bad motive in doing so?
No, I don't think so, Justice Barrett. I think that it operates based on objective facts disclosed to counsel. Counsel then provides the advice, in this case, the Department of Justice, and it's an objectively valid defense. It's a complete defense to prosecution.
So what would be so bad? I mean, one thing that strikes me as different, well, one thing that's obviously different between the public authority defense and immunity is an interlocutory appeal and having it resolved at the outset. What would be so bad about having a question like that resolved at the threshold, having it be an immunity? The same kind of question that could be brought up as a defense later, but have it be brought up at the threshold as an immunity, and then interlocutory appeal would be available, and it would be a freedom from standing trial, but not a get-out-of-jail-free card.
Yes, I understand that, and I think that if the court believed that that was the appropriate way to craft presidential protections, it has the authority to craft procedural rules that implement its Article 2 concerns. That said, public authority, calling it a defense, but under many statutes it's actually an exception to liability itself, and what you're really talking about is trying the general issue. And generally in criminal cases, even cases that involve First Amendment issues like threat statutes, the jury is the determinant of the facts. And I have a little bit of difficulty with the idea of trying the whole public authority issue separately to the judge and having that go up on interlocutory appeal with review of facts before you could ever get it forward into a criminal case. That said, if I would prefer a regime in which the court altered some of the procedural rules surrounding the president than a total, absolute blanket immunity that takes away the possibility of criminal prosecution, even if it was a core violation of the statute in the teeth of Attorney General advice and has no overriding public purpose.
You think it has to be a jury question? I mean, let's see, I wasn't necessarily proposing actually treating it as a defense that was done at the outset and then subject to interlocutory appeal. I was proposing, what about an immunity doctrine that drew from the public authority defense that the Department of Justice thinks would otherwise apply? So just go with me on that for a minute. Why would it be so bad for it not to be a jury question? I mean, it seems to me that some of these Article 2 concerns would be exacerbated by having it go to a jury rather than a judge.
So I think some of them are judge questions that could be resolved on the face of the indictment. If the Department of Justice ever returned an indictment that said the issuance of this pardon or this series of pardons constituted obstruction of justice, I have a little difficulty hypothesizing it, but a motion could be made on the face of the indictment that says Article 2 precludes Congress from regulating these activities. The indictment needs to be dismissed. And if the court wished to attach to that kind of a rule interlocutory appeal, then that would be a lesser safeguard than the one that my friend is proposing here.
Thank you, counsel. The case is submitted.
All right, my friend. So that is it. And we have a lot to unpack. And we are going to debrief what we saw. But my take on this at the outset is that this was more of a success than I think you may initially feel. And the reason why I say that is because the government had some major concessions here. We saw that they even agreed that there was, in fact, immunity that exists. They called it something else. They called it a bunch of different things because they don't like labels. You know, they don't like to even call people by their genders and stuff like that. So they just, identify as something else. We say, that sounds like immunity. They're like, I'm pretty sure that's immunity. They say, no, I identify differently. But as we were going through this, I did pull up Judge Chutkan's original order just to show you how blown out of the water she was after today's oral arguments. This is what she wrote about in her prior motion, U.S. versus Donald Trump. This is Trump moving to dismiss this case based on presidential immunity, okay? And so what did Chutkan say? She says, this court has a duty not to decide stuff that's outside of scope, okay? And so we're going to limit our holding here. Now, I want to show, right? It says, we don't decide whether former presidents presidents retain absolute criminal immunity from non-federal prosecutions. So that's not what we're talking about in this case. This is a federal criminal prosecution, right? Which is what we're talking about in SCOTUS. So she's saying, I can't rule on Fannie or Alvin Bragg. Okay, that's fine. I also can't review whether sitting presidents are entitled to greater immunity than former ones. Okay, so she's not deciding that either. Okay, we got it. But defendant Trump asserts that former presidents have absolute immunity for acts within the outer perimeter, but says even if I were to accept that assertion, I wouldn't grant immunity here because there's a bunch of different questions. And here's what her ultimate conclusion is, right? Because it concludes that former presidents, not Trump, not in this case, not limited to Trump, not only, right now, former presidents, Chutkan's conclusion is they do not possess absolute federal immunity for any acts committed while in office. And that's not what I heard from the government today. Now, he was very careful not to use this phrase, right? He never used the other side's terms, which is smart. They very much adhere to their labels. But Chutkan, right, this is what we're appealing. We're appealing her order. She says there is no absolute immunity for any acts while committed in office. But she says the court doesn't need to reach those additional issues, and so we express no opinion on them. And then she kind of punted this down the road to say none of it applies here. She spends the rest of her opinion talking about how the First Amendment doesn't apply, it doesn't matter, and due process doesn't apply, doesn't matter in this case. But here, right, absolute immunity says Trump doesn't have that. And that's not exactly what we heard from the government in this case. We had Dreeben come out, and Dreeben came out and he says, well, there's public authority exceptions. So if a president does something, you can't prosecute him for that. Why? It's an exception to the law. Oh, that's interesting. Sounds like immunity. So today we had a lot of discussion between these two guys about mechanics on how this worked. And I think that actually supports the Trump immunity position. So it is a beautiful day, my friends. I'm very grateful that you joined us. I think this was a historic oral arguments, maybe one of the most important and consequential oral arguments that we hear as it relates to our federal government and how it works. And so we're grateful that you are here and joining us. Thank you for subscribing wherever it is you're watching this. Of course, thank you for liking this video as well. And we got some great links down in the description below. Would love to invite you to our locals community, watchingthewatchers.locals.com. We do member streams in the morning. We do after parties after the streams are over. We have an amazing community and a lot of fun. And we'll look forward to seeing you over there and back here on the next one.